Hello. Good morning, friends. I am Nitin Upadhyay. I am a professional company secretary and uh, consultant in IPR. And today we'll be looking at the topic which is introduction to IPR. So, what is IPR exactly and how it is helpful as far as the entrepreneurs or the industry is concerned? That we'll try to discuss some of the aspects of IPR. In relation to that, we'll start with this particular PPT. As of now, I am a visiting faculty at Joshi Bedekar College, Thane. At the same time, I am a visiting faculty at ICSI, that is Institute of Company Secretaries of India. So I'm catering to the requirements of the budding company secretaries at ICSI. So this is my background, and with this small introduction, uh, I would start with the topic that is intellectual property right. That is IPR. Commonly, the short form is an IPR. Fundamentally speaking, IPR, the term is referring to a creation of a property that is a creation by the mind as well as an intellect. So it is a creation which is not a tangible creation, but it is a creation which is a outcome of the implementation of the thought process as well as the intellectual capacity of a person. And that is why this particular term is known as IPR. So in this particular context, we'll try to elaborate and explore certain areas of IPR, that how IPR is connected with the industry, and what are the areas where industry can protect their intellectual properties under different headings. So broadly speaking, IPR will move on to the next slide, and we'll try to discuss what are the types of IPR. Before moving to that types of IPR, would just like to discuss certain things. What are the organizations and that those organizations are governing the IPR as far as the whole world is concerned or the whole globe is concerned? So WIPO is an international organization, that is World Intellectual Property Organization, and that head office is situated at Geneva, Switzerland, and it has got almost 188 members, or rather, the 188 countries are the members of this particular WIPO. So almost practically speaking, the whole world is having the membership with WIPO, excepting or excluding certain few countries. But practically speaking, almost the whole world is connected with this WIPO. So this is a governing body as far as the IPR concern globally. And we'll try to understand what are the types of IPR. Broadly speaking, what are the areas where IPR can be just protected with different statutes which are uh, designed and which are been enacted by that different countries. So according to that, there are major four areas of IPR we can understand in a common parlance. There are more than four areas. There are a number of areas of IPR, but in common parlance, we can see that copyrights, trademarks, patents, industrial designs, and trade secrets. These are the commonly known areas where we can say that there is an existence of IPR. Then we'll try to explore one or two aspects of this particular thing. As far as the time factor is concerned, we'll try to cover one or two areas of IPR. And what this particular, before going to the particular aspect of IPR, we'll try to understand what this particular IPR means as far as the industry or the proprietary business or any type of entrepreneurship is concerned. What is this IPR is contributing to? So IPR is connected with the value creation as far as the property of a company is concerned, wealth generation, that is the profit earning, and wealth realization. So that is how the IPR is connected with all these aspects, which are we can say essential aspect of any type of business activity. Apart from that, as far as the issues are concerned, how the IPR is dealing with those issues. Normally, we are always observing certain areas or certain aspects which are appearing in the newspapers or in the news channels, and that is always a battle between the news prospecting, sorry, sorry, knowledge prospecting and knowledge piracy. So it is always there are certain people who are having certain skill set, certain knowledge, and they are having certain inventions, certain ideas, and naturally there are some other category, we can say that those ideas are being rather captured illegally by the other people, and that is why we are always seeing the disputes between the piracy of knowledge as well as the prospecting people. They are having their knowledge and they want to implement their knowledge. So that is how the IPR plays an decisive role as far as the industry is concerned. Intellectual property relevance. What is the relevance? We'll see increase in the exposure to copying, detection, and distribution. So there are number of areas where the people are trying to copy a particular thing, whether it is legal or illegal. That will be decided as far as the uh, whether if it is properly taken a permission from the original author or not. Then realization of value of a brand. So there are number of brands available in market and how to protect those particular brands. People taking their IP seriously. Nowadays, people are very serious as far as their IP properties are concerned or intellectual properties are concerned. So they are trying to protect their properties, and naturally, the courts are also so much vigilant and so much expeditious, I will say. In today's scenario, we are seeing a lot of decisions which are being rather which have been discussed and which have been disposed of by high courts, many high courts in India. Uh, to name a few, Delhi High Court and Bombay High Court, they are leading high courts where most of the IPR decisions are very expeditiously taken care by these particular high courts. See, as far as IPR is concerned, we try to understand whether it's movable property or not. Uh, Practically speaking, it is a movable property because though it is not a tangible property, we cannot touch it, but we can transfer this property from one person to another. That is one natural person to another natural person, or one natural person to legal person, or legal person to legal person. All possible ways we can transfer this property from one person to another. So this is a movable property as far as the Transfer of Property Act is concerned. This is considered as a movable property. And connected with that, there are number of dealings happening in the industry that particular trademark, particular brand, particular patent is being transferred, is being owned by particular company, and that is now it has been transferred to some other company. So that is how this particular transaction happens, and that is how it is in the category of movable property. And the important questions as far as the people of rather the general understanding regarding IPR is concerned, people are always getting confused that which type of IPR is suitable to my particular intellectual property. That is a big question mark in the minds of people, because they are not aware of the IPR statutes as well as the significance of IPR. So they are under impression that uh, normally what we are seeing is that the people are rather having the conceptual understanding, it is completely missing. So people will always call any IPR is it's my patent. So that is how we find the people, and it is always a confusing factor as far as the common man is concerned. So there are IP attorneys, there are consultants who can guide you that what are your properties, what are your IPR your company is having or you are having, and how it can be protected under the relevant laws. So that will be a very good job as far as the legal consultants is concerned, and the proper advice is concerned as far as the IPR area is concerned. This is a particular slide which is depicting the gist of IPR. There are 4 to 5 IPRs depicted here. So in this case, we'll try to understand one by one. As far as copyright is concerned, the idea is connected with expression. So that means your idea is getting protected if it is expressed in a proper format. That is, we'll try to understand with this particular thing with some examples also, but that is how the idea plus expression will give you the result, that is copyright. Idea plus idea, that is connected with innovation plus invention, and that will give you the area which is known as patent protection. Idea which is connected with the quality and identity, that will give you the outcome of that is trademark. Idea which is connected with only the appearance of an article, that is connected with the Designs Act. And idea which is a specific formula or specific formulation, that is a secret formulation we can say, and that is coming under trade secret. So these are the major areas as far as the IPR is concerned. Apart from this, there are number of other areas for IPR also. So we'll try to cover at least we'll try to understand what is copyright. Copyright is in India, the Copyright Act 1957, and it is amended in 2012, and accordingly there are certain provisions of copyrights. So copyright is formally speaking, it is a bundle of rights. So it is having a, it is not a single right, it has got a number of rights associated with a single copyright, a particular enactment. So there are 6 main categories. We'll try to understand those categories later on. We'll just try to see how the copyright work is getting protected. And this is a typical symbol you can see in the slide, that this is a typical symbol of copyright. You will get this symbol I think almost 99.99% of books whatever available in the market, those books are having these type of symbols always there, and copyrights protected. All this particular guideline is already issued in that particular book. Right of reproduction. So how this copyright is connected with the rights of reproduction of work, a communication of work to public, adaptation of work, that is a modification in original work, a display of your work publicly, and make derivatives of work. So you can convert that particular script into a particular drama, particular movie. So that is coming under all the activities are coming under derivatives. So once you are having a copyright, you can have the rights over all these activities which are depicted over here. So a particular person who has got a copyright or who is an original author of that particular thing, he can have he can exercise all the rights as far as all these parameters are concerned. So always whenever you say right, then there must be some left. So accordingly in this copyright concept also, there is a copy left concept. A copyright means you have got a right, and you are only allowing a particular person to exercise that right under your permission, legal permission, then only that other person can do certain activities. That is copyright. A copy left is a phenomena which is a form of licensing, that one can use a particular work which is an original author has done, but original author is licensing some other person to use that particular work, and accordingly the other person can use it without claiming that it's mine. So that is what is known as copy left. So copy left is open to all, but it is a sort of licensing. So original author will give license to somebody, that the licensee will use that particular thing under the license which is issued by the original author. So in that way, this is known as a copy left. So it is exactly an opposite of copyright. And how the copyrights, which areas are being protected under copyright is very interesting. There are major 6 areas. Apart from, there are other areas also, but major 6 areas are of more importance as far as the copyright is concerned. A literary work, dramatic work, musical and artistic works, these are the major areas. As far as the cinematograph and sound recording, these are the major areas which are covered under copyright. So I will take a few examples. This is a very common example, a very famous example. This has happened as far as the very famous movie, which is by Mr. Amir Khan. And there was a dispute between Amir Khan and the original author, that is Chetan Bhagat. And the Chetan Bhagat's claim was that this particular movie was based on his particular book. He has written a book that is Five Point Someone, and based on that, this movie was casted, and that is how that dispute has started. But fortunately, this dispute has not gone into higher levels. This was settled out of the court, and that is how. But this particular dispute was there, and definitely it was a serious matter, and that is how. Sorry, that is how that particular person, or rather we'll say Amir Khan, has settled out in outside the court of that is the preferred choice by this person. See, what happens in normal copyright is that most of the time this particular picture is showing that a particular line or particular tune or particular poem, a particular a poet is creating a particular poem, and he is discussing that poem with his friend. And if the friend uh, goes to his desk and he just writes down that particular versions, and if he signs that particular document that this is mine, and afterwards he claims that this particular poem original creator is me and not my friend. In that case, it's very difficult for the original person to prove that this particular poem was my creation, because the other person has done the needful, and he has expressed in particular. So in this case, in the first slide what we have seen, that it is a expression that is getting protected. See, idea is not getting protected unless it is expressed. So it has to be expressed in some tangible form, then it will get a protection. So if you have got certain things in your mind, but unless you put it on paper, unless you put it in some tangible form, it cannot get protection, or it cannot have protection under Copyrights Act. So that is how the copyright is important as far as the protection is concerned, and the idea and protection is concerned. Under this copyright, then important area is that if we consider that suppose we are photocopying certain material, suppose a particular singer is singing a particular song of a particular person who is no more now, and if a particular recipe is being done at home, that is a cooking recipe, so all these things, whether it is infringing the copyrights or not. So these areas we'll see that these areas, or we can say these activities, are coming under the fair use, and this fair use is well defined in section 52 of the Copyright Act, Indian Copyright Act. So fair use means if you are doing a particular activity with no intention to tarnish the image of the original creator or the original author, and you are not using it for the commercial purpose, then it can be considered as fair use. So whenever you are doing any photocopying of any particular material, it is not an infringement of a particular author, rather particular right of an author. As well as suppose we can take an example of Johnny Lever is doing a mimicry or doing a imitation of certain big artist. So in that case, it is just for a fun purpose, or it is, though he is getting certain remuneration of that particular show, but ultimately whenever he is doing this performance, he has got no ill intention to do that particular activity. So that is why it is coming under fair use, and that is how the copyright is how it is utilized as far as the original author is concerned. There are two types of infringement occurring in copyrights. One is known as primary and one is known as secondary infringement. So there are certain remedies also available. You can go to the court of law and sort it out. One important aspect while concluding this copyright topic, I will just try to elaborate on this particular thing, where the Berne Convention is coming into picture. So we'll try to understand this Berne Convention, and then we'll finish off this particular topic. So Berne Convention, practically speaking, this is there are number of signatories to this Berne Convention, and there are two principles used: the principle of national treatment and principle of automatic protection. So under these principles, if you can interpret these principles, so practically speaking, if you want to register your work under Copyright Act of USA, suppose, because India and USA both are signatories to this Berne Convention. So if you are registering your work directly into USA rather than registering it in India, so practically speaking, if it is getting registered at USA, you will get all the protection in all the countries who are the signatories to Berne Convention. This is a interpretation of these two principles. So practically speaking, you are registering your work in only single country, but you are getting almost protection throughout the world, because the signatories of this particular Berne Convention, almost all countries are the signatories to this particular Berne Convention, and that is how you will get the protection throughout the world. Though other rather the other IPR are not having that we can say extraterritorial jurisdiction or the protection over, we can say, uh, in the other country you cannot get the protection of trademark who is registered under Indian Trademark Act. So that is how the copyright is, and I think I can conclude this topic because of the paucity of time. And with this, I'm thanking you all, and we'll see you in the next lecture. That is what is trademark or any other area that is patents. We'll see in the next lecture. Thank you so much. And I will conclude this particular topic. We'll see you in the next lecture. Thank you.